the part heard appeal in the matter of Microsoft Corporation and others, and JJH Enterprise.
My lords,
Before you start, can I just ask you how long you're going to be? That's not because I want you to be 2 minutes, that's not my point. I just would like to have a sense of how long you think you're going to be.
by my calculations, about an hour.
Okay.
Subject to your lordships, of course, which I think will leave about 20 minutes or so for Mr. Hobbs in reply, with the remaining time for my learned friends.
Okay.
So I will address the grounds relating to the first preliminary issue,
Mm-hmm.
grounds 2, sub-Roman numerals 2, 3, 4, and 5. The tribunal's overall conclusion at paragraph 108 of the judgment under appeal, which we don't need to turn up just yet, was that the exhaustion rule did not preclude the respondent from subdividing and reselling the individual user rights granted by Microsoft to the first acquirer of an enterprise-wide license. I will seek to persuade this court that that conclusion cannot stand, focusing on what we say are 4 errors in the judgment. First, the failure to apply what we say is a clear rule in UseSoft itself against subdivision of a block or multi-user right. That is to say, a grant of rights for a specified number of users. That's ground 2, sub-Roman numeral 2. Secondly, the tribunal's errors in construing the specific Microsoft agreements here, which constitute the user license. That's ground 2, 3, insofar as it is relevant to look at the terms of the license. And third, the tribunal's reliance on a decision of the Bundesgerichtshof in UseSoft 3, which it then used to read down what we say is the CJEU rule, and to substitute in its place a novel test that what matters is simply whether there are more copies in circulation than were originally licensed. Mm-hmm. We say that test was contrary to UseSoft in the CJEU and wrong. That's ground 2 as well, but a different sub-paragraph of it. Mm-hmm. Finally, fourthly, the tribunal's failure to address the agreed and admitted facts of the sample transactions, by reference to which this PI was to be determined. That's grounds 2, 4, and 2, 5, which I'll address together. Okay. Now, why all this matters, my lords, is that the respondent's business, admittedly, relies on subdividing large enterprise licenses, typically covering thousands or even tens of thousands of users, from the single block, or the economic unit, in which they are sold by Microsoft, into much smaller parcels for downstream resale to retail and other customers. Mm-hmm. It's common ground that VL, the respondent, did in fact subdivide for each of the sample transactions. Mm-hmm. That's clear from the statement of facts, common ground, and it would have done so in the counterfactual for the purposes of its substantive competition claim. Mm-hmm. So, turning to the first error, on Microsoft's case, the respondents admitted subdividing should have been the start and end of the first preliminary issue, because we say UseSoft categorically prohibits it. So I'd like to begin by going to UseSoft, which I hope your lordships have that authorities bundle, tab 20.
Just a minute.
One can pick it up at page 453 of the authorities bundle, if you're looking electronically. That's where the judgment of the CJU begins. And the first paragraph I would like to take your lordships to is paragraph 21 on page 456. This is the factual matrix that the CJU was presented with in the order of reference, also appears in the Advocate General's opinion. The software at issue was licensed under what was called group licenses, which allowed customers to acquire from Oracle, the database software, in fixed quantities of 25 users. So if you had, say, 27 employees, you had to acquire 2 packs, giving you 50 user rights in total, and leaving potentially 23 user rights surplus. That's in paragraph 22. Paragraph 23, continuing over the page, sets out the terms of the relevant license grant, which I can produce and summarize as essentially permitting unrestricted internal copying within the business, of what was supplied by Oracle on its website, subject to the limit of the number of users that had been specified in the block. And the defendant's business, UsedSoft in that case, was to take the excess licenses from the block and resell them, pay money to the first acquirer in lieu of those user rights. Paragraph 26 is also relevant. Customers of UsedSoft who don't yet have the software would download a copy directly from Oracle after acquiring the user rights on the used secondhand market. And if they have the software already and then purchase further licenses, then they're induced by UsedSoft to copy the program to the workstations of users. In other words, every user who is accessing the database software is making a local copy on their workstation as well in the course of accessing it. And then one sees that again at paragraph 33. UsedSoft customers do in the dispute and main proceedings by downloading a copy of Oracle's program onto a computer from Oracle's website. Just pausing there, that's the critical copy which is exhausted if the conditions are met. Or uploading it to the main memory of other workstations, in other words, installing it on the workstations of the users. And they're allowed to do that up to 25 times. One can then jump ahead to paragraph 44. This is just to really contextualize what follows. This is a critical link in the CJU's reasoning. It must be observed that downloading a copy.
So where are you now?
Paragraph 44 on page
44,
44, my lord, page 460. Do hold me up if I'm moving too quickly through it. The court essentially analyses the user license agreement and the copy which has been downloaded from Oracle's website, i.e. that copy, as an indivisible whole. So you have to take the license with the downloaded copy. And then the subsequent paragraphs are really concerned with the question of whether by licensing that downloaded copy, there is a first sale for the purposes of exhaustion. And held, yes, there is. That's not the part of the decision that matters for the purposes of PI1, but it is the context to what follows. I would just pause briefly and note, for your lordships, note paragraphs 48, 51 and 60, which are more relevant to PI2, Mr. Hobbs' submissions. Doubtless Mr. Hobbs would have taken you to them directly if there was time, but I just paused to mention them because they make clear what's said on this side of the tram tracks and sort of the other side of the coin of what's later said in the top cabinet. So the key passage for PI1 purposes is paragraphs 69 to 71 on page 464. This is after the court has concluded that there is a first sale by making available a downloadable copy and licensing it to the enterprise. And it qualifies that principle in an important way, which we say is actually decisive of PI1. And I would just seek to draw three propositions from this passage, paragraph 69 to 71, which I respectfully commend to your lordships. First, if the license relates to multiple users, that is to say it's what I'm calling a block right or a single economic unit, it can be resold as a block, but it cannot be subdivided and resold for a smaller number of users, which is determined by the licensee, first acquirer.
That's a proposition. You're not reading it off the page here.
No, that's the proposition I'm seeking to extract from paragraph 69 in particular.
Let's just have a look at 69.
So if the license acquired by the first acquirer, that's the customer of Oracle, relates to a greater number of users, that's the block of 25, as stated in paragraphs 22 and 24 above, which I've shown you, then the acquirer is not authorised by exhaustion under Article 44.2 Software Directive to divide the license and resell only the user right corresponding to a number of users determined by him. I'll explain the policy and the doctrinal foundation for that limitation in a moment. That's the proposition that the CJU is articulating.
It turns upon what's meant by user rights specifically, doesn't it?
Of course, but one sees that from paragraph 22, 23.
It's quite limited, what's meant by user right in the context of the licenses in question.
It's the right to use the software, which includes making reproductions of the software on your workstation, which you inevitably do when you use any software because you reproduce a copy of it in memory of the computer when you run it.
I think the respondents might take a different view of what's meant by user right in this context.
Yes, it is the block right which is granted by the copyright holder to the licensee, the enterprise. Now that may be measured in a specific quantity of users, or it may be an unlimited number of users, but it's that right. And what the CGU is saying is that that right can be passed on, but only as it stands, in whatever terms it's granted, which makes sense. The second acquirer can't acquire a better or different right to what the first acquirer had.
So the fundamental point is that, I mean, if I sell you a car, you can only resell one car. If I sell you 100 licenses, you can only resell 100 licenses, because that's the economic bargain that's been struck between Microsoft and the first purchaser.
Precisely. That's what the copyright holder has consented to putting on the market, that block. And that is, I'm anticipating my latest submissions, but that's essentially the balance that the CJU is striking between the interest of the copyright holder to control the first distribution of their work and the other competing policy interests of free movement and competition.
You say that if I've granted you a license for 1,000, use it. I'm not allowing you to subdivide. Exhaustion doesn't limit subdivision.
It's not. You can certainly transfer 1,000.
But you can't sub 1,000 times 1.
Precisely. It's a policy against fragmentation of the user right.
Well, that's the real issue here, isn't it?
Yes.
Once your right is exhausted, can you break down 1,000 into subdivisions, smaller numbers?
Well, the CJU is saying in terms you can't, because
That
the
depends
user
on how you construe what's 69, 70 and 71, doesn't it?
Indeed, but the user license is an indivisible whole with the copy. So it's saying you can't disaggregate the restrictions in the license as to what is granted in the first place to the first acquirer from the copy that's being downloaded. It would.
If I sell you 3 motor vehicles, why shouldn't you resell them one by one?
Well, it's a very different context of tangible goods, objects, which are, in a sense, independent of one another, can be used independently. Yes.
But the licenses are all independent of each other. They can be used by different people in different ways.
Perhaps, I mean, it's all a question of what's granted.
Yep.
Here we're concerned more with the minibus.
Well, it depends on what's meant by exhaustion, not necessarily what's granted.
Well, just to take the analogy and run with it for a moment, if I may, my lord. You put to me 3 cars, but what Oracle was selling was a minibus that seats 25 people, saying you can't rip out the seats and pass on 2 seats to someone else.
But you can with it. If I buy a minibus, I'm perfectly entitled to take the seats out and sell them to somebody else.
Indeed, but in the context of exhaustion of software, the CGU has laid down a rule, like my respectful submission, which prohibits the licensee from doing something that the grant of the user right to them does not allow.
Yeah, I mean, that's your submission. We do understand your submission, Mr.
Well, if you're against me on the principle,
Why does this, just help me with this, I'm looking at 69. 69 begins with an if. It should be pointed out, however, that if license acquired by the first acquirer relates to a greater number of users than he needs. So everything that follows is premised on that situation.
yes.
Now why, given that that's what is said there, how can one interpret whatever is said after that as being a general proposition that you can't disaggregate a collection of licenses? What it's saying, what as I understand it, you rely on the rest of that paragraph as saying that in general you can't, if you have a license for, this is saying if you have a license for 1,000 you can't split them up, but this starts by saying what it's talking about is a situation in which the purchaser has bought more than they need.
Well, if they didn't have more than they need, they wouldn't be seeking to pass on some quantity.
That's not true, Mr. Reardon. I can buy 1,000 because I need 1,000, and then later, 2 years later, I decide I don't need any and I sell my 1,000. I always bought what I needed.
Well, in my respectful submission, that's not a qualification on the principle. The court is dealing with the effects of the exhaustion of the distribution right. That is what it says in the middle of the paragraph. Those effects.
What's the point in terms of the reasoning of the court? What's the point of this premise? Reproduction.
Yes, every time a user uses the software, they will be reproducing copies of it in memory.
I understand.
The exhaustion of the distribution right does not affect the reproduction right. That is why you need the user license to go with the copy. Otherwise, it would not be a very useful thing to acquire. you might have the seat, you can't put it in a bus, you can't run it, you can't move in it without infringing another restricted right. That's why the court, realistically in my submission, treats them as an indivisible unit. So I would respectfully differ from my Lord Spurs in treating the opening clause of paragraph 69 as a sort of precondition.
Okay.
It is articulating a general principle as to the effects, the scope of exhaustion of the distribution right, not saying anything about exhaustion of the reproduction.
So your submission is that paragraph 69 can be read without the words if. Effectively, those words are surplus and can be ignored. And the proposition is true whether or not that if condition is satisfied. That's your submission, that's fine, I get it. I mean, that happens.
Yes, it's not so much a condition as it's just dealing with a particular scenario.
If.
Yes. I don't shy away from those words, my lord, at all, and in my submission my point stands with or without the words. More importantly, when one looks at the sample transaction in this case, and indeed the respondent's business, it's always about surplus licenses that are being resold by businesses that don't need them.
Okay.
So that is the context for PI1. That's why this matters. Anyway, that's the first proposition I seek to extract from paragraph 69, and it becomes clearer as we move through, because the CJU repeats this a number of times in its judgment, and the CJU doesn't repeat itself lightly unless it's important. Anyway, the second proposition is that it does not matter whether each user of the software makes their own local copy on their workstation or just accesses a copy which is stored centrally. One gets that from paragraph 71, read in conjunction with paragraph 70. The 70 explains that the first acquirer will still be using the copy of the program installed on his server, and thus will not make it unusable. And that's why they can't, if they want to, if they need to, if they don't need it, whether they do or they don't, that's why they can't subdivide. It reflects one of the core conditions for exhaustion, namely you must render your copy unusable before the time of the resale transaction. The CJU goes further and specifically adds in paragraph 71 that even if no new copy is made by the acquiring user, so that the net number of copies in circulation stays completely neutral, still the effect of exhaustion does not allow the excess user rights to be transferred and acquired by the second acquirer. That's what paragraph 71 is saying. And just to hark back to second one versus point a moment ago, in the second line of paragraph 71, the words "and hence a new reproduction" are important. Temporary or permanent copy on a workstation by a user will be made whenever the software is used. That's what the usage right is. It's the right to make that copy when you run the program. It's how you use software. And that will inherently involve exercising reproduction rights, even ephemerally, every time the program is used. And the CJU is saying, in my submission, it doesn't matter whether the second acquirer is just going to augment their contractual rights to be able to make additional copies or not. Either way, this is not part of the legal effects of exhaustion for computer programs.
Just at a technical level, is what you said about what they're talking about correct, Mr. Reardon? Because it doesn't talk, it's not, I don't, well, as I read the first sentence of 71, it's not talking about the copy which is loaded into the memory of a computer when you run a program. It's talking about putting an installation on your server.
That's right. So that's definitely right in terms of the second acquirer not installed, because they already have a copy installed on their server.
Sorry,
I'm not explaining
I
myself.
misunderstood you. I thought because you made the point, and you obviously like to draw attention to it, that it says hence a new reproduction. And I thought the submission that you just made, Mr. Reardon, was that the new reproduction that's been referred to was about loading computers into memory to run them. But I don't think that is what it's referred to, because that's in the context where they're talking about a new installation on a server. You tell me, but that's how I read it.
So paragraph 71 is dealing with a particular example which doesn't actually arise on the facts of used software. The CJU is going out of its way to point out that there's no relevant distinction between subdivision of a block license involving only a central copy, which is already installed by a second acquirer, and one where they have to download the software and install a fresh copy themselves. And my point is that it can make no material difference of principle whether that copy is stored on a server or on a workstation. Now, it's true, I'm extracting that proposition. It's not said in terms in paragraph 71, So I hope that has clarified my submission. The third proposition, and just to state the obvious point on that, my lord, that there is no exhaustion of the reproduction right. And that is why it cannot matter whether the copy is ephemeral or permanent, central or workstation based. The principle that we're getting with paragraph 71 is clear. You can't, as a second acquirer, augment your user right, just as the first acquirer can't diminish their user right on a purely contractual net neutral number of copies basis. The third proposition I would seek to extract from these paragraphs, and then I will to move on, subject to the court, is whether the user license agreement, which is linked to the first sale, is characterized as a single license covering multiple users, or as a bundle of individual licenses in a particular quantity, does not affect the principle that's being articulated here. The non-division rule arises simply from the fact that the economic unit of the first sale is that block, which is tied to a specific quantity of users. And the CJU is telling us that exhaustion does not permit the first acquirer to pull out the seats from the bus. So we say this is a clear autonomous rule of EU law of general application, which does not depend on the details of the specific license. The proper approach should have been to analyse the first sale and ask whether it relates to a specific quantity of users. That's the user right. If it does, then the first acquirer is not entitled as a matter of law to subdivide into a smaller quantity. That's so whether they need to or want to or have surplus or decide they want to make a profit or do redeploy their existing assets. Their subjective motivation for reselling does not matter. And that is so however one construes the license agreement, whether as a bundle of individual licenses which are all bought by the same enterprise together, or as a monolithic grant of a right to download and use in a specified quantity. So we say that's a clear rule.
Does that mean sorry, let me just make sure I've understood that. Let's say, I know you might say I would be mad and no doubt I'd be out of business very quickly, but let's say I was a company selling software and I wanted to make it possible for my purchasers to, I didn't mind if they sold second-hand software, just to give it a name. I know it's more complicated to call it that. And so I made it clear in my license that they wanted 100 licenses and they're getting 100 licenses.
Well,
you say that still doesn't work because the law says you can't do it.
So that would
That's
depend.
what I thought the submission was you were making.
That would depend on what is granted. Obviously, you have to look to the license to characterise the first sale, and that will involve inevitably construing the license to see what is granted. Plainly, if the rights holder consents to subdivision, then that's fine. That arises from consent
Into
rather
my
than
contract
exhaustion.
that I hereby consent to subdivision. I just sell 1,000 licenses. You're saying if I sell 1,000
my submission is
licenses, the law is they can't be subdivided.
That's a block. Can't be subdivided as a matter of law. If you want to permit subdivision, then of course you're free to do so. In fact, Microsoft does permit, in certain circumstances, transfers of individual license rights under a block grant. But there's a procedure for doing that, which I'll come on to address later. And that's based on consent rather than exhaustion by operation of law.
That's irrelevant to the question of whether there's exhaustion.
That's precisely my point. This is a rule of law.
Yes, quite.
So a good illustration of what I'm submitting hopefully more clearly now is provided by Ubisoft itself. So as I've said, Oracle granted rights in packs of 25 as a block. On the CATS analysis, this could be seen as 25 individual end-user licenses to make 25 copies on 25 workstations, as undoubtedly it did allow. I showed you the general ground in paragraph 23 of the CJU judgment, which permitted internal copying by the business of what is provided by Oracle. And each of those workstation copies was indeed theoretically capable of being used by different employees in different enterprise to connect to a different database server. The CJU said, in my submission clearly, that the first acquirer still could not subdivide the economic unit 25 block and sell on any surplus user rights. Now, your lordships may be thinking, well, what about other multiples? If they acquired 2 blocks and got 50, could they sell 25? Or 1,275, could they resell 1,250 of them? In my submission, the answer would still be no. The economic unit the subject of the first sale, assuming they bought all of that in one go, is the block of 50 or 1,275. And the right holder may have allowed, in theory, the licensee to make other choices as a matter of commercial terms between him and the licensee. But in fact, what was chosen and what was sold, put on the market with the consent of the right holder, was that block. And it's that block that must be resold together if at all.
That means that there's a fundamental difference between this kind of exhaustion and the exhaustion that comes from selling a tangible product.
Yes. This is an incident of the lex specialis. We're now very much in the realm of computer program copyright. We're not talking about other kinds of copyright. And as Manuel will know, different exhaustion rules pertain to different types of intellectual property rights, and that's to be expected. So my submission is the rule.
The point is that if you sell, if you were selling a pack of 1,000 CD-ROMs, software on them, you telling me the law would be that doesn't allow someone who bought 1,000 CD-ROMs off Microsoft to sell individual CD-ROMs? I rather think they could.
What your lordship is putting to me is a slightly different scenario where you're not downloading from a website.
Absolutely, not
And
downloading, absolutely.
the CJU is dealing with a scenario where you have an indivisible grant in the user license coupled with download. It's not essential to my case that the CD-ROM example be prohibited.
It's not.
It's not relevant to my submission.
Well,
So it's not very economically, there's no difference between the transfer by something physical and the transfer by something digital. In the modern world, nowadays everything's done digitally. 10, 15, 20 years ago, it might have been a mix. What logically differentiates a physical transfer and a digital transfer in explaining the difference between exhaustion?
The potential prejudice to the right holder, given the ease with which digital copies could be multiplied without needing to retain the physical view.
It's 1,000 remains 1,000 remains 1,000. So 1,000 discs or
we don't-
1,000 digital copies.
We don't know that in practice. It's much harder to police digital copy. Obviously, the CJU accepts that a digital sale is equivalent in many respects to a physical sale, and that's why it concludes the way it does on the first question before it. That's not the issue I'm intending to focus on for this purpose. It doesn't mean that if that had been the CJU's view, that it's equivalent for all purposes, it wouldn't have said what it said in paragraph 69 to 71. Another way of thinking about it is that in the physical world, you can hand over objects without exercising the reproduction right. I can pick apart about 1,000 pack of CD-ROMs and give one of them to somebody, and I haven't exercised the reproduction right. And that person could be a lawful acquirer of that copy and then exercise their rights under Article 5.1 to make copies when they want it. Whereas in the digital world, I can't hand over a copy without someone authorising the reproduction.
Why is that? I see that. Why is it relevant?
Well, it's a difference of principle between the two mechanisms of distribution, and
One involves reproduction and the other just handing over a physical copy.
yes, and reproduction right is not exhausted.
But that's always just the difference between digital transfer and physical transfer.
Yes, but for copyright lawyers, that difference matters.
In copyright terms, I'm thinking about the references earlier on in the judgment that exhaustion shouldn't be an excuse to artificially partition markets and things like that. References in the directive too, in a sense, this area being subject to other principles which are about market unity.
Yes.
I'm just trying to get my head around what the logic in the distinction is. I mean, I can see what's said, and I have to think about the wording of what's said, but what's the logic of the distinction? I mean, you may just say it's old law, it's a lex specialis, there it is, full stop.
So I can give two answers to these points, I think, just to draw it together, and then I will have to move on if I may. In economic terms, one must balance, as the court is doing, the rights of the copyright owner against other policy considerations like free movement, competition, not segregated markets. What the judgment that we have from the CJU represents the CJU's attempt to do that, to strike that fair balance. And in my respectful submission, that's the balance which has been struck, and it includes the rule against non-division of the digital distributed copy. The user right that goes with it in whatever quantity it's granted. Now, that may seem arbitrary, but it isn't, for the second reason I'll give you lordships, which is that as paragraph 70 explains, the reason for the rule against subdivision is that it's a necessary consequence of one of the core conditions for exhaustion to arise. namely that the first acquirer must first delete or render unusable that copy which was acquired from the right holder. Now, if I give you a CD-ROM, I've surrendered my copy. But I can't do that if I'm continuing to use that copy that I downloaded, albeit for a small number of users. I still have that copy in my possession. Yes. I'm reminded by Mr. Hobbs that in our skeleton we refer to the decision of the Supreme Court in News Corp and Ireland Limited and HMRC. We probably don't have time to turn it up, but I will just give your lordships the reference to paragraphs 115 to 117 in Authorities Bundle, tab 12, page 217. Yes, the passage beginning, I was initially impressed by the argument made by News Corp that the finding that the content of the digital and printed editions of a newspaper were fundamentally the same or very similar could lead to there being no sensible reason for treating them differently, in that case for the purposes of VAT writing. But actually there were relevant differences. Now, in a sense it doesn't matter because my submission to you at this point is CGU has given us the rule, CAT was bound by it, we're bound by it, we should apply it. But it so happens that there is a logical doctrinal basis for it, as I've started to explain in relation to the conditions for exhaustion.
Can I ask you, just to understand, paragraph 69 is referring to the license,
Yes.
not multiple licenses.
Yes.
And thereafter the discussion is in relation to effectively the license and user rights.
Yes.
The number of people who can use that license.
Yes, the license can cover permissions for multiple users, and that was the case here. One has to understand that phrase, the license, by looking back to what is said, paragraphs 44. In particular, that's on page 460 of the bundle. It's the indivisible whole of comprising the downloading of a copy from the rights holder's website and the conclusion of a user license agreement for that copy.
Well, don't we get it from 22, where it explains that you may have 25 users for one license. If you want 27 users, you need 2 licenses.
Yes, 2 blocks. 2 blocks.
Plus 2 licenses.
Yes, well,
Not blocks of licenses, it's a license.
in Oracle it was a single license agreement. It's just your user right would be 25 or 50 or whatever number you agreed with Oracle. You didn't enter into 2 license agreements. That's very, very clear. So I'll come on to address that.
I mean, I'm not sure you. I think the thing I'm trying to understand is whether you've addressed the point that's taken against you by value licensing, which is that this is not looking at multiple licenses. It's looking at a single license, which has, in respect of which multiple users are permitting to access it.
Well, as I said, that must entail 25 licenses, 25 copies or 50 copies or however many users there are. You may not make all of those copies internally, you may not use all of those user rights, but they're all covered under the same license agreement framework. In my submission, the court is not limiting the principle that it's articulating in paragraph 69 to any particular structure of a contract. It's looking at a matter of substance. Does the grant by the rights holder relate to a specific quantity of users? If it does, then you can't subdivide that block. And it doesn't matter whether you treat that as a single license agreement or as 25 licenses that are just sold all together. The first sale is that economic unit which was agreed between the right holder and the first acquirer.
Can I ask just one point, which I must say, checking backwards and forwards in the judgment, I can't find an answer to. The last few words of paragraph 69 really determine what restriction which continues after exhaustion applies to. It's resell only the user rights for the computer program concerning corresponding then to a number of users determined by him. So I doubt it's in dispute that if the license is for 25 users, the resale can't be for more than 25. Is this saying here to a number of users determined by him that if the licensee wants to sell that 25 block license to 50 people, it can't do so, because that would be a number of users determined by him?
No,
And then you'll say no.
The opposite.
But, well, where does one find that? Because like, that makes...
The second line, my lord, greater number of users, not lesser.
Yes, well that's the first condition. The license says 25. You can't then resell to a number chosen by you, which could be more than 25.
It could, but it could also be less. The CGU is not limiting it to more. The point is, exhaustion arises from the acts of the right holder, not the acts of the licensee. It's the putting onto the market with consent. And it follows that it must be the act of the right holder that gives rise to the first sale and the parameters of that first sale. What the court is saying is that exhaustion and its legal effects do not extend to an act by the licensee in deciding what the parameters of the resale will be, i.e. the number of users to which it will
But
relate.
they're not if they stick to the quantitative limit imposed first time around.
No,
They're not determining, they're sticking to the rules, as it were. And
no, they're not. They're not sticking to the rules because the rules are you can only buy blocks of 25.
And you would say the word block is really critical. You can't then sub-block.
Whether one calls it an economic unit, a block, or simply the user right which is acquired in the first sale. Whatever you're calling the first sale, that is what the right holder has consented to put on the market in that configuration with the contractual parameters associated with it. That's an indivisible whole, and exhaustion doesn't allow the licensee to then change the parameters of that sale by changing the number of users in the user right, up or down. Obviously, it couldn't go up because it would be authorizing infringements, things acting wholly outside the license.
In just picking up on the point in paragraph 22 that my Lord Justice Phillips identified, the reference to 27 acquiring 2 licenses and the fact that then the rest of the judgment paragraphs we'll be looking at, 69 to 72, talk about the license. Am I right in understanding that what's contemplated there is that for the sake of argument, if the undertaking had acquired 27 users and therefore had 27 users and therefore acquired 2 licenses, your submission is that this judgment would mean that they could sell a block of 25 and a block of 2.
That's the multiples of 25 point that I raised earlier.
Right.
And
you accept that?
No, my position is,
Don't accept
my position is, whilst you might in theory be able to buy 25 or 50, if you've chosen to buy 50, that's the transaction, that's the first sale.
So why does it say 2 licenses in this judgment?
It doesn't matter. It doesn't matter, my lord, because the first sale is the economic block that's been agreed between the right holder and the first licensee.
So this judgment should have said 1 license.
No, doesn't matter at all to my argument whether there are 2 licenses or 25 licenses. It's the submission I've been endeavouring to
Well, I know
make.
it's your submission. I'm trying to understand the judgment, Mr.
I understand.
Sorry, but what 69 is about would divide the license. What it means is you can't sell off some of the users.
Yes, that's all they're saying. But one has to be quite careful in the analytical structure of all this. Exhaustion arises from a first sale. The first step is to identify the first sale. The first sale may comprise one agreement or several agreements, a suite of agreements, but it will typically be one transaction, one consented act of putting onto the market. And for my argument, and in my submission to the Court of Justice judgment, it's not prescriptive as to how many licenses there are within that first sale. They're all treated as an indivisible
But it's a different thing though to say you can't divide a license and saying that if you've got 2 licenses, you can't sell one of those 2 licenses.
But even in that scenario, if your lordship was against me on the multiples of 25 point, you couldn't break apart the 25 pack and sell it in sub-quantities of your choosing. And that's sufficient for me to succeed on
for
the
myself, I understand why you say you can't break apart the 25, but I don't understand why you say, as I think you do, you can't sell the 2 25s to different people.
Because that's the
What
first
judgment do you say that arises?
paragraph 44, 69, that's the first sale. One can see it repeated also at 85 and 86, and maybe just to try and make progress, because I'm very mindful of the time, I'm already 40 minutes. That 85 and 86 may be a better place to see it. That's on page 466. And I do apologise, 84 might be a more sensible place to start. So it cross-references back to 44 and 48, which I've taken your lordships to, the downloading onto the server of a copy of the computer program from the website and the conclusion of a user license agreement for that copy form an indivisible whole which must be classified as a sale. So it's saying the first sale is the combination of the license agreement and the copy. That's not referring to a license or a quantity of licenses, it's referring to an agreement which gives you the contractual architecture for the sale. And then later in paragraph 84, it's referring to resale of the user license. So there is a distinction being drawn between the sale and the user license or the user right. And whilst one might have a sale with more than one user right in it, where one does, we're in paragraph 69 territory. And then in paragraph 85, there's a reference to the position of the new acquirer, the second acquirer, who will be able, under Article 5.1, to use the copy of the software because they're a lawful acquirer thereof, so they can make reproductions of it. But paragraph 86 importantly qualifies that. It should be recalled, however, that if the license acquired by the first acquirer relates to a great number of users, that acquirer is not authorised by the effect of exhaustion distribution right under Article 4.2 to divide the license and resell only the user right corresponding to a number of users determined by him, referring back to the paragraphs we've seen. In other words, that is qualifying paragraph 85, so it's saying that the second acquirer can't then rely on being a lawful acquirer and reproduce that sub-quantity of copies, which is consistent with what is said in paragraph 1771. So I'm going to have to move on, my lords, but that is our sort of bright line rule submission, that the CJU has struck the balance in this way. That represents a policy against fragmentation of the user right associated with the first sale. And whether that's contained in one agreement, multiple agreements, one license, multiple internal licenses, does not matter. If your lordships are against me on that, then we're into my next round of appeal, which relates to construction of the license agreements here. In other words, what one must do, assuming that one must look at the parameters of the license agreement, is work out whether it is correctly construed as a multi-user right relating to a specific quantity of users, and not individual licenses that can be individually resold. And that's a question of characterization of the rights granted under the agreement, which must be a question of interpretation of the associated user license agreement. Now, the meaning of the contract, I think it's common ground, is a question of law on which this court is entitled and indeed bound to form its own view. What I would do is turn up the tribunal's reasoning on construction, however, to explain our concerns with it, which is in Core Bundle, tab 12, page 171. That's where it begins. So paragraph 63 starts by setting out a number of selective clauses, and then it quotes selectively at paragraph 64 to 66 from the unchallenged evidence as to how the software is distributed. So each customer gets a single link to the Microsoft server to download the installation file. Although it's not said here, the unchallenged evidence was that that is done by the customer logging into a special software portal where they get their product key and they can get the download link to their copy. They are then free to make internal copies of that software, as we will see. 65 explains that multiple activation keys, product key, Mac, and there are other activation systems that are equivalent. At paragraph 69, the tribunal summarizes the effect of the above agreements. The customer can download and install from Microsoft the number of copies of the products it had ordered upon enrollment. I'll explain why that's not quite right, actually, but that's what they say. The product license becomes perpetual after 3 years, assuming all payments have been made. That is right. Now, paragraph 70 summarizes Microsoft's argument, inaccurately in my respectful submission, that it accepts the respondent's submission that there is a bundle of independent licenses within this Microsoft suite of agreements. And at 71, it gives 3 reasons for that, which I'll go through in detail in a moment. And at 71, it concludes that multiple licenses are purchased rather than a single license for multiple users and devices. Now, it comes back to this at 96 and 98 to 106. Initially at paragraph 96, it says the contractual analysis is irrelevant because exhaustion operates by law and it can't be affected by the contract. As I've hoped to explain, sought to explain to your lordships, Usoft either lays down a bright line rule to the contrary, or at the very least requires you to consider the terms of the associated user license agreement in order to figure out what it is in fact granting. And in any case, what the tribunal subsequently goes on to do is to rely on its interpretation of the grant as multiple independent licenses. So I do need to explain why this reasoning was wrong. And I'll focus on 3 errors of construction, as we say. The first error is at paragraph 63, subparagraph 1. The tribunal misunderstood the nature of the right granted by Microsoft to the enterprise customer and the specific quantity of users that it covers. That's because clause 2 of the enterprise enrollment is only partially quoted. The crucial text is truncated. The full clause your lordships will find in the supplementary bundle, and I would like to turn it up, please, at tab 13. Page 108. This is the enterprise enrollment. This is what the customer actually signs when they join the enterprise program. And the supplementary bundle, tab 13. And this incorporates by reference a suite of other agreements, some of which we'll need to look up as well. Clause 2AI, which is on page 110, requires the enrolled affiliates enterprise, probably the customer and any nominated other entities in their corporate group, have minimum 500 qualified users or devices, in other words, setting a floor on the organization size. And then in sub-revenue numeral 1, enterprise commitment, the enrolled affiliate must order enough licenses, capital L, I'll come back to that, from the product pool for each enterprise product ordered to cover all qualified users and or all qualified devices. Material about subscription services are not presently relevant. That's the enterprise commitment. The customer has no discretion in the quantity it orders. It must order the exact number of users sufficient to cover all of the users in the organization, all the devices in the organization, subject to a minimum floor of 500. Just jumping back to the definitions, because they're important, on page 109. The enterprise product, for present purposes, it's common ground, that includes Office and Windows. And that's something which must be licensed for all qualified users and qualified devices on an enterprise-wide basis. That is the core commitment which is given by the enterprise in return for the other benefits of this program, preferential pricing, payment terms, and you'll see a lot of flexibility in how they make their copies and manage them. Qualified device, midway down page 109, essentially, just to summarize in the interest of time, essentially any device that runs the software, any client device, including PCs and laptops. You can install any number of copies on that device, for example, 1 per user of a shared device. Qualified user is essentially any natural person who uses a qualified device or accesses the server software stored centrally on the server. A user may use multiple devices, like a desktop computer, a laptop, their mobile, maybe they have a work-at-home PC. So each user may have multiple copies, and indeed an unlimited number of copies. Under a single user license, there can be multiple copies of the software on different devices. The tribunal had 2 sources of evidence as to the commercial purpose of this enterprise commitment, both unchallenged, one from each party. Microsoft's evidence was given by Ms. Kaysen, that supplementary bundle, tab 34, pages 367 to 368, though I won't turn it up. Customer who wants the benefits of the enterprise program must commit to license everyone or everything. That's how it works. Smaller businesses who don't wish to make this commitment can opt for a different licensing regime that's available to them called the Select Agreement. So you don't have to join up to this program, but if you do, that's the commitment you need to give for Microsoft Office and Microsoft Windows. The second source of evidence was from the respondent's own expert, Mr. Golev, who described supplementary bundle, tab 29, page 307, the enterprise commitment as the core principle of the enterprise program. He said it means licensing the software enterprise-wide for everyone or everything, which is given in return for the benefits of that program. So the commercial bargain, which we say was embodied in the enterprise enrollment, was a commitment to license a precise quantity of users or devices on an organization-wide basis. No more, no less. And the resulting grant, as I'll explain by reference to the license grant in a moment, is a block right or an economic unit in that specific quantity, which is transacted as the first sale.
I note in little one, enterprise commitment, it uses the plural when it refers to licenses.
It does. I'll address that specifically in the tribunal's reasoning in a moment. Now, could one then turn to the enterprise agreement, somewhat confusingly named, which is at tab 12 of the supplementary bundle, page 103. This is another of the agreements which is incorporated by reference into the enterprise enrollment. While we're here, just note the definitions. Customer is the entity that enters into the agreement. The enrollment is the one we just looked at. The enterprise is the enrolled affiliate and any other entities within its corporate group that it specifies. License, this is my Lord Justice Burst's point, capital L, means the right to download, install, access and use a product. And a product is Windows or Office, for example. Second and third sentences are relevant. So that's just a label, a permission to download, install and use a product, meaning that you get the right to get the software and make use of it. And I'll come back to that in the context of what we say is the third error. On page 104, clause 2A is the actual operative license grant. There's a few points to make about this. The grant by Microsoft to the enterprise, single grant, license grant. And it's a right to download, install and use the software products in the quantity ordered under an enrollment. And just to show how that works, there's one further document I need to show you as part of this suite of agreements, and that's the product selection form, which is at tab 14, page 117. So this is another document which will be entered into at the time of signing up to the enterprise program and placing the order. And you can see it's linked. This is an example from a specific enrollment, one of the sample transactions. And just in the interest of time, I'll just take you through the key parts of it. The first table, step 1, profile enterprise, and it lists the number of qualified devices and qualified users in the organization. For the purposes of my example, for Office, that's qualified user licensing model, 22,434 qualified users. And that's an enterprise product? Yes. In other words, the enterprise commitment applies to that. That's the number of qualified users in the organization. And then if one looks in step 2 to the first 2 lines of the table, one sees that there are two slightly different versions of the product, but the total that's ordered is 22,434 throughout those 2 numbers. So could not have bought a right covering 22,433 users, or 500, or 1. It could only buy a block corresponding exactly to the number of qualified users in this enterprise. So in a way, it's even more restrictive than Oracle's terms, at least more prescriptive, as to the commitment that the enterprise has to give in order to get the benefits of this program. And I just point out over leaf on page 118, you can see the pricing level which is offered is pricing level D, which is applicable to 15,000 users and above. Now I should just point out in that table, pricing level D, quantity of licenses is repeated. Now again, I'll come back to that, but that's just a label for permissions to download and use the product. That's the number of users that can do that. So what we have is a license grant in a specific quantity of qualified users, which the licensee has absolutely no discretion to modify. It's a block corresponding to the size of the organization's user base in this example. And that will always be the case. Now there are other software which is not subject to the enterprise commitment, but they're not relevant to this issue in this appeal. But for Windows and Office, which are the economically important products for present purposes, they are subject to this commitment. And so that, we say, is a key feature of the first sale. And it's one that the tribunal completely ignored at paragraph 63 and subsequently. Another very obvious reason, in my respectful submission, why the tribunal must be wrong is that an enterprise-wide product key, the MAC, will ordinarily be shared by all of these users. A single product key. That's another reason why you can't rip out the seat from the bus and use them independently. They're all sharing the same product key, confidential product key. And it's unique to that enterprise. Sometimes very large enterprises might have a small number of product keys if they run out of activations, but in general, they will all share one product key. They let you activate 10,000 copies at a time. And that's essentially for administrative convenience, so you don't have to search for the product key for Joe Smith, which you've left on a post-it note somewhere. You have one key that all users can share, because it's a block grant to your whole enterprise. And Microsoft, of course, allows that because it's part of the flexibility given to members of the enterprise program. But more importantly, it doesn't matter that they could, in theory, activate more copies locally. They've already committed to license their whole organization. And that's reflected in the economic terms of the order. So that's error one. In terms of how that maps onto UseSoft, your lordships may be wondering, Oracle granted licenses in fixed blocks of 25. Let's suppose, for present purposes, if you get 50 user rights, you have 2 licenses. Customer had no flexibility to order less than 25 if they needed a smaller subset or a non-multiple 25. But they did have flexibility to order 25 or 50 or 75 and so on. Here, Microsoft grants rights in blocks which are tied to the exact size of the organization's user base, 22,433, for example. So that is an even more precisely demarcated economic unit, multi-user right, than in UseSoft. It's tailored exactly to the enterprise. So we say, like UseSoft, what they share in common, why we say we're within paragraph 69, the key characteristic of the first sale and the associated indivisible user license agreement is that it is tied to a specific quantity of users, which is determined and indeed imposed in rules set by the right holder and agreed to by the first acquirer. So the rule.
Is that realistically what's actually going on? I mean, I'm just trying to think. If you've, I can see that you're using the quantity to set the price. That makes perfect sense. But there are very few organisations that have 22,434 users who are going to have a precise number of users for very long. It's probably going to go up or down.
Your Lordship anticipates my very next point. This is the second error. The tribunal relied on what's called the true-up procedure under these licenses, which is precisely that procedure that your Lordship has in mind. An organisation doesn't remain static, it will grow or shrink over time. And under the license terms that I've just shown you, the customer must acquire and maintain a quantity which corresponds exactly to the number of users in the organisation. Can I just show you that, if I may, back in tab 13, so we're back in the enterprise enrolment, supplementary bundle, page 110. Clause 2G, subparagraph 2, additional capital L licenses for previously ordered products other than online services may be added at any time, but must be included in the next true-up order. Second sentence is irrelevant. And then 2H, true-up requirements. Enrolled affiliate must submit an annual true-up order that accounts for changes, so changes to the number of users or devices since the initial order or the last order. If there are no changes, then an update statement is submitted. For enterprise products, the enrolled affiliate must determine the number of qualified devices and users at the time the true-up order is placed and must order additional capital L licenses for all qualified devices and users that are not already covered. In other words, the obligation, the precise demarcation of the user right, not just exists at the time of the initial order, but throughout the term of the agreement, which is a 3-year term. So in a way, that's it's a point in my favour, my lord. It's even stricter in time. It's a 4-dimensional obligation as well as in space. Now, the tribunal thought this was something that supported the existence of a bundle of independent licenses theory, because the customer could increase the quantities at any time and in any number. They employ 50 more people and they buy 50 more licenses, capital L. But in my submission, the key word here is must. There's no discretion. The customer is not deciding what quantity of user rights it wants. The top-up obligation simply reflects the nature of the enterprise commitment, which is to order and to maintain that specific fixed criterion as to the quantity. Obviously, a perfect synchrony can't be achieved in practice between the size of the organisation and the number of permissions that have been ordered. That's why in practice you have this annual procedure to top up the
I mean, it may be perfectly sensible. It assumes that everybody nowadays is going to use the software one way or another, or the code one way or another.
Yes,
even if you're a janitor who doesn't, but that's just the rounding at the edges.
Well,
It's qualified
Not-
users.
it's a qualified user who uses a qualified device. The janitor may not be using any device,
Yeah,
so you
okay.
would. But yes, we're talking about Windows and Office. So we're talking about organisations that
Yes,
have
fine.
bought into the Microsoft family,
Yeah.
and one would expect all of their qualified users are going to be using that software. That's precisely correct.
It's a reasonable exercise for an annual catch-up exercise is pragmatic.
Exactly. And it reflects the trust that Microsoft places in its enterprise licensees to do the right thing, to keep track of the number of qualified users and submit the orders. And of course, it's backed by an audit procedure.
So presumably in practice, if a new employee, the 22,000, whatever it was, 35th employee, the day after the deal was all signed, was given the Mac code and downloaded it, it would all work. The computer's not going to turn around and say, you're one more than the number, you can't have it.
No,
It's
that's
not
right.
the way
It's
it
all
works.
licensed. There's one more clause I will show you in a moment, but it's all licensed. There's no infringement just because you go one over. It's
That's
just
the
an
annual
administrative catch-up.
Yeah.
And that's the flexibility the enterprise gets in return for the commitment. So it's all part of a bargain which we say aligns over time with the size of the organisation in practice. Yes, and Mr. Hobbs reminds me that the license that is being conferred is a license to download, access, install and use, i.e. to reproduce ephemerally and permanently the software for each of the qualified users and on each of the qualified devices. Now, one subtlety here, well, not subtlety, it should be obvious, this is a one-way ratchet. It's a true up, not a true down. Now, if there are big changes in the size of the organisation downwards, there is another procedure to have effectively good faith discussions to work it out if there's a demerger or something. But that's based on consent and being commercial. It's not based on a right to arbitrarily change the user quantity downwards. So the block size, we say, remains fixed according to the same criterion to keep pace with changes in the organisation during the 3-year term. And that's all of a piece with UsedSoft. The difference, of course, is that rather than 25, the unit size is whatever it is, 22,433, or as may grow. But it's just as fixed a block as an economic unit. So I will have to move on, if I may, to the final area of construction, as I'm now very much in injury time. So this is the plural point, licenses plural. The tribunal placed heavy weight on this label and the fact that it was pluralized. That's paragraph 70, subparagraph 1 of the judgment. I've already explained that this is a defined term. It's essentially shorthand for a permission to download and use in the quantity ordered. But the problem with the tribunal's reasoning is that the choice of label cannot affect the substance of what is granted and the restrictions applicable to the grant. And the tribunal's reasoning, in my respectful submission, is superficial and favours form over substance. One must look to the substance, and on that I will give you 6 short points. There's one transaction with the enterprise, one first sale, not 22,433, that's obvious. There's one set, or one package of written agreements, not 22,000. The block of user rights is obtained all at once in one helping, subject only to the annual top-ups. There's one customer and any named affiliate entities, and the single grant of the license is to that one customer, not to the individuals. Finally, clause 2A is the singular grant to the enterprise of the right to download, reproduce and so on products in the quantity ordered. Now, all of those features are ones which my respectful submission should have led the tribunal to conclude that, so far as it's relevant, this is a single license which is granted as a block to the enterprise, not in respect of individual workstations and individual copies made by users. There's one other important feature of these agreements which I do need to draw to your attention very briefly. That's back in the enterprise agreement, tab 12, page 105. And it's clause 3A. This is referred to by the tribunal at paragraph 63, subparagraph 3, but not picked up again later. Just in the interest of time, what it says in summary is that the customer is allowed to make as many copies of the products as are reasonably needed within their enterprise. So there's no cap, and as I've already explained, there is no one-to-one relationship, or certainly no necessary one-to-one relationship, between the number of users and the number of copies, because they might have multiple devices. The organisation might also keep a stock of spare devices with the software pre-installed in case there's a malfunction and someone needs to get up and running again quickly. That is part of the flexibility and trust that the organisation gets in return for the enterprise commitment. Now, considering my learned friend's case for the respondent, if he were right, then theoretically the organisation would be permitted to make a huge number of copies, an unlimited number of copies, and then subdivide and resell them, mint copies. Now, none of that destabilises what we say is the unitary nature of the licence grant. The respondent can't be presupposing that every employee who has a copy of the software on their workstation has their own independent licence, as in independent of all the others, with a right to resell it on its own to anyone. And I referred earlier to the policy against fragmentation. And the policy is this. In the sample transactions, a total of about 500,000 user rights were transferred from Microsoft's customers to VL in 5 sample transactions. The figures, that's just adding up the figures in the statement of facts, supplementary on tab 7. On the respondent's case, those 500,000 user rights could be sold individually. Many of them were. So that Microsoft then has a direct relationship with 500,000 individual end users, whom it then has to support, where once it had 5 enterprise agreements with 5 block rights allocated to users and devices within each enterprise. And all with those tens of thousands of users sharing the same product key, and each of them able to activate up to 10,000 copies. So conversely, if my case is accepted, then those blocks can be transferred in the economic units in which they were first sold. And that means that Microsoft can only ever be faced with 5 enterprises to which these user rights may be allocated and lawfully be transferred. Each with its own associated product key, unique enterprise, and user license. Now that in my submission is another good reason for the rule against subdivision, although I accept it's not express in the language of the CJU judgment that I've taken with Phillips too. So in terms of the impact of these errors on the reasoning of the tribunal.
Isn't that just a consequence of used soft? Used soft means that in the context of intangible products, you are forced to have a relationship with someone you never would have had a relationship with. Whereas with tangible products, that doesn't happen. If I buy a 6-pack of beer, I take each of the beer bottles. Beer is a bad example because I'm not allowed to sell it. Coca-Cola. And then I can take each bottle and sell each one separately. That doesn't create new relationships between anybody and Coca-Cola.
But that's why subdividing a 6-pack may not represent as much of a prejudice to the
I
right.
understand. My point is the other way around. My point is that once used soft has decided that you can sell second-hand online software, it creates the situation you're talking about. Your point is it gets much worse if you can disaggregate it. I understand that, but the problem your client having a relationship with people that never, as it were, wanted to, if I can put it that way, is inherent in used soft.
Respectfully, that begs the question, doesn't it, as to whether exhaustion goes that far. And my analysis of used soft that I've commended to Lordships.
Even used, sorry, just if you
doesn't.
don't mind, if you even used soft on your submission would allow your customer to sell the whole lot to a different person, the person that Microsoft had no relationship with.
We
before,
entirely
they
accept
won't have
that.
Yeah.
Yes, and that's the consequence, Your Lordship, is
Okay.
I think referring to, we can't control who is ultimately the enterprise. We've accepted that risk, as it were,
Yeah.
by putting the block on the market. But what we haven't ever accepted the risk
What's
of.
that? You say
is
you haven't accepted, you don't want to have
fragmentation.
500,000 separate relationships. I do get that.
So just to finish on this ground, and then I may have to sit down. In paragraphs 105 and 106 of the tribunal's judgment, called under page 182, the tribunal refers back to its earlier reasoning for rejecting Microsoft's contention that there is a single block user right rather than a bundle of independent licenses. So although it says in 89 to 96 the contractual construction is irrelevant, it's all operation of law and so on, it's not what it actually does subsequently. But what it then does is takes a real leap and says that because it can't see how to distinguish a single license from multiple licenses, what matters is not the contractual distinction, but whether there are more copies in circulation than originally licensed. That's paragraph 105 of the judgment under appeal. Now, I can take this very shortly because I've already, I hope, explained it, but that's a novel test which we say is categorically ruled out by use of paragraph 71. That's certainly not in the language of the software directive in Article 4.2. Whether or not a second acquirer brings additional copies into circulation by reproduction doesn't have any intrinsic relevance to exhaustion of distribution right. So we say the test applied by the CAT cannot stand on any view, and then in my submission we're back in the realms of contractual construction or the bright line rule. The tribunal came closest to getting it right at the end of paragraph 105 when it said that the first acquirer is permitted to resell what it purchased. Had the tribunal correctly construed what it purchased in the enterprise agreements in the first sale, it would have been apparent that what an enterprise purchases is the right to download, install and use the products in a specified quantity. And that specific quantity can be transferred if the relevant conditions for exhaustion are met, but what USOF doesn't allow, what exhaustion doesn't extend to, is subdivision. Now, if I'm right on that, then that's the end of this claim. It's common ground. I haven't addressed you orally on USOF 3. I may have to see how my...
Let's have a little, let's a bit more on USOF 3, Mr.
This is the final pillar of the tribunal's reasoning. It obviously placed great weight on the Bundesgerichtshof decision. It's a separate case to USOF 1, although the defendant was the same. There are probably 3 points I can make very briefly. First, it's not a subdividing case at all. That appears from 92 of the CAT judgment, page 178 of the bundle. There were 40 single-user licenses purchased by the first acquirer, and it then resold those 40 licenses to Usoft, who then resold 2 of them. But the lower court held, as a finding of fact on the German procedure, but there we are, that these were independent licenses, not a block. So there was not a user right covering 40 users, there were 40 individual licenses. And that was treated as a finding of fact which had not been appealed. That's paragraph 47 of USOF 3. Just for your lordship's note, authorities, tab 49, page 1016, paragraph 47. So there was no block user right at all, just 40 individual licenses. So it's specific to its facts, it can't be elevated into a general principle. The other key feature of the facts, of course, is that the first acquirer did not install the software at all. It just forwarded it on with the installation media. So it kept nothing. It wasn't continuing to use the software. It divested itself of that copy that it had acquired. No more, no less. That's paragraph 49 of the BGH decision. So there's no obvious transgression of used soft on the facts of that case. Second point is that the non-division rule, the CAT tried to read it down so as to be limited to a particular type of client-server software. Now, my submission, although the factual context of USOFT was that you had a central copy on a server, and you had clients that then made their own reproductions locally, doesn't matter. Because in each case, you need to rely on the user right in order for the workstation to make its copy, whether that's temporary by accessing the server, or permanent by installing a local copy permanently. Both involve an exercise of the reproduction right, which is not exhausted. So it cannot matter.
Say that again.
It cannot matter whether the copy on the workstation is temporary or permanent. It's not a
It's
material
temporary, isn't
distinction.
it covered by other exceptions? So maybe it does matter.
No, because they wouldn't be a lawful acquirer. They couldn't rely on those exceptions.
When they are.
Well, if the point your lordship is putting to me is it might be covered by temporary copying because it's not of any independent economic significance, that's not a point that's been raised. But if it were raised, it would have to be rejected because plainly when you pay on a per user basis, it is of independent economic significance. So, but that just begs the question of construction again. So this is in paragraph 98 of the CAT judgment. They identified a distinction in use of 3 between a single copy of software held on a central server for use by multiple users, as in Usoft 1, and individual licenses, as in Usoft 3. And my submission is, actually, if you look at the paragraphs of Usoft 3 that I took your lordships to at the beginning, 22, 23, 26, 33, and so on, there are copies on the workstations as well as on the server. And a first acquirer can't be any better position if there's no copy on the server and only copies on the workstations. At 101 of the CAT judgment, the tribunal rereads the requirement that the first copy be rendered unusable not as a condition of exhaustion, but necessary for the seller to avoid infringing the reproduction right. That ignores the fact that PI1 was actually directed to both the reproduction right and the distribution right, precisely for this reason. So anyway, I've already made the submission that paragraph 71 of Usoft is inconsistent with this approach. The same restriction on non-division and non-augmentation of the user right applies even if no additional copies are made. The a fortiori, it must apply where additional copies are made. At a more basic level, my lords, the position on Usoft 3 can be summarised like this. Either it's saying no more than the CJU did in Usoft, in which case it doesn't add anything, or it's positing a fact-specific exception which seeks to read down Usoft, in which case it can't alter legal principles.
I've never understood what read down means. What do you mean by that?
Seeking to limit the non-division rule, as I've called it, to a specific software architecture, rather than something which is just a limitation on the illegal effects of exhaustion, where you get a multi-user right to software.
Does this all boil down to whether Usoft, CJU 69 and 70 are two separate principles or one principle? 70, I think this is the point the respondents take, is that this is all about destruction of the copy by the original licensee. And that, I think, is the position the JJH took in 2013 in its first judgment. And that, I think, is supported by the fact that paragraph 70 of the Court Justice's judgment refers to the situation in the preceding paragraph, which is 69, which is the one you relied upon. So you say 69 standalone, that's stands alone, it's irrespective of what the original licensee does to the copy that it has. Whereas the respondents say it all turns upon whether the licensee destroys the copy, in which case then they're free to license on and subdivide.
Yes and no. 69 is the principle, 70 is, as I've explained, the rationale, or part of the rationale for the principle, and 71 is an even if, dealing with another scenario where there's no extra copying, but it still doesn't let you subdivide. And the point I'm seeking to advance in my submissions is that the precise architecture of the software is immaterial in the context of that principle in 69. Because in each case, whether you have a central copy or workstation copies, use of the user right is going to entail reproduction. And so if you retain any copy, i.e. a downstream derivative copy of that copy that you downloaded from the right holder, then you won't be complying with the condition for exhaustion in paragraph 70. Yes, and I'm reminded by Mr. Hobbs of 86 and 87 of Usoft as well, which repeat this very point. Put another way,
They all use this rather genomic term user right, which is defined in two ways.
yes.
And the destruction, and one is permanent storage on your own server, and the second is limitation, quantitative limit on the number of users.
Yes,
And
yes, that's precisely right, Mike.
so the user right therefore has two meanings, and not always clear in which sense they're using the meaning, and particularly when they start talking about destruction of the use. That really goes to the first definition of the user right, not the second.
It goes to both, because if you destroy the copy, then it can't be accessed, and therefore you can't make reproductions of it.
So they already have disseminated it, your 1,000, you may have said, sell 1,000 rights, then destroy, and thereafter you can't.
You can't do that. You have to destroy before you Well, you have to render unusable before you transfer, and then destroy.
Is there something which says before or after?
At the time of resale, I think it says at the time. Now, in any case, I won't have time to address
Anyway,
you all,
alright,
but
yeah.
the sample transactions made clear that the supplier of the respondent did continue to retain that copy which they downloaded, because they often sold batches of subdivided rights, or in every sample transaction. And so they did continue to hold that copy they downloaded from Microsoft centrally and carried on using it
Until
for a
they got
small
to the
number of
maximum
users.
number, as it were.
They never got to the maximum number,
Okay.
which
I understand.
yeah, and the same product key for all of them. So that's why I say this is a principle rather than something which is limited to a specific type of software. Even if I'm completely wrong about that, finally, on the Bundesgerichtshof own distinction, this case falls on the client-server side of the line. We get that from the joint statement on definition of the products, which was the factual basis for the PI1, which is a supplementary bundle, tab 64, page 765. Paragraph 5. So they are both workstation and client-server software, designed to work with and do work with other Microsoft software that can be installed on a customer's own servers. Let's see the examples. So it's common ground, therefore, that Windows and Office, although downloaded permanently onto workstations of qualified users, are designed to communicate with and do communicate with the centrally installed copy of the Microsoft software, which is also licensed. Yes. Yes, and my learned friend Mr. Hobbs reminds me that paragraph 1 of this statement is the source of the definition of what the products are, capital P.
Complex.
That's the complex subject matter. Now, back in the judgment at paragraph 67, this is accepted, page 172 of the core bundle, and a finding of fact is made. Skipped over before, but it's relevant now. Bottom of page 172, customers may also enter a CAL, which is not directed to the product per se. This is a type of user right, but instead permits access to the Microsoft servers where the products can be accessed. CALs are necessary to access the server. So it's just an illustration of how this is client-server software in any necessary sense. It's certainly hard in my submission to see what it is, if not client-server software of the sort under consideration in Microsoft 1, if that is the target for which we're aiming. Now, I've overstayed my welcome by some margin, and I've not managed to address you on rounds 2, 4, and 2, 5. So I will pray in aid of what's said in my written submissions, and if time permits, to address any points made in reply. The key point on those grounds is that Usesoft requires the tribunal in this court to respect the contractual framework that goes with that copy, paragraph 79 of Usesoft. Can't ignore it. If the contractual framework lays down procedures, requirements, they are binding on the first acquirer, and the second acquirer cannot stand in any better position than the first. Now, true it is you're not permitted to prohibit a transfer. These agreements don't do that. To the contrary, they contain an express clause saying that the user can transfer wherever they have a right to do so because of exhaustion.
Thank you very much, Mr. Reardon.
Can I just
Yes, of course, sorry.
the CAT set out a number of references to where in the agreements there's references to license plural. But I was interested in, you took us to the document at 117 of the supplementary bundle, an example subscription enrollment product selection form.
Yes.
And over on the 118, you did show us, but I didn't pick it up at the time, that where it's looking at price levels, what they relate to are quantity of licenses.
Yes, I hope I did point that out at the time.
It does seem to suggest there that Microsoft itself regards itself as granting 22,434 licenses.
So it's a capital L point. This is obviously part of the same suite of agreements. The definition is in the other document I showed you in the enterprise agreement. Licenses just means the permission. It's just the user right. I hope I've made the submission clear that 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 label can't determine the substance of what is being granted in the first sale.
Thank you.
My lords, unless I can assist you further on PI1, those are my oral submissions. I'm just reminded that
Go on then.
before court, we did email a hand up, which
Yes.
was intended to save time.
Yes.
It consists of no more than references to the non-programmed works and to the evidence about them, which was unchallenged and accepted by the tribunal. But we hope that's convenient, rather than flicking through.
And
some-
info back too.
And info back, yeah. And info back.
Thank you, Mr. Reed. Yes.
So, my lords, we maintain.
Just as I asked Mr. Reed when he started, how long are you expecting to be?
Well, I anticipate I'll be able to give mine and from Mr. Hobbs the 20 or 25 minutes at the end he requires.
Okay.
That's an anticipation, not a binding promise, but
I'll promise it then.
Mr. Hobbs can be very, very fast in reply.
He can. Well, can we see how we go at anyway? Yes, so we maintain the position indicated in our skeleton that the judgment should be upheld for the reasons given by the tribunal. And I may not have time to take you to everything in our skeleton, but we do continue to rely on it and all the specific answers we give to the detailed grounds of appeal. But if I may, I'll begin with preliminary issue 2. And my approach to that will be as follows. First, I'll make some general submissions as to how we say exhaustion applies to complex matter. And here I'm using the term complex matter or complex work in the sense used in Nintendo to mean something that has both program and non-program elements. I'm not using it in the sense of something that comprises only non-program works, but of different types, because in that case one only has InfoSoc to consider. I'll then deal with the Berne Convention, TRIPS and the WIPO Copyright Treaty. And the short point is that Berne and TRIPS don't deal with exhaustion, and Article 6 does not mean what Microsoft says it means. I then have a short point on the interplay between the two directives, and then I'll go to some of the case law and explain how that leads to the conclusion the tribunal reached, and which we urge upon you. So then our general submission on how exhaustion works in case of complex matter. But it's worth looking at what Microsoft's position must be. It boils down to the proposition that the inclusion in Office or Windows, or indeed any other computer software product, of any non-program works in which copyright subsists effectively takes the product outside the exhaustion regime of the software directive. So Microsoft say it follows that so far as its provision of intangible copies of Office and Windows concerned, or indeed any other software product which is complex matter supplied in intangible form, there can be no exhaustion of the distribution right. That's the position Microsoft get to. Our position is more nuanced. We say there's a spectrum of products one can envisage comprising complex matter in the sense I've described and in the sense used in Nintendo. And we say that for the purposes of exhaustion, one has to make an assessment as to where the product lies on that spectrum. So at one end of the spectrum, one can consider, for example, products that are primarily of a literary, artistic or dramatic character, that's just an example, but which includes some program material, the purpose of which is to allow the user to access and enjoy those works. And those are cases where it may be said the program material or element is only incidental in relation to those works and is not the essential element of the product. And you'll appreciate that there I'm using two terms used by the Court of Justice in paragraph 59 of Tom Cabinet. So in those cases, the InfoSoc exhaustion regime should apply. rather than the software directive regime. At the other end of the spectrum, there are software products where the software is purchased because of its functionality, and the non-program material is there to further the usability and usefulness of that functionality. And the tribunal found, in the case of Office and Windows, the non-program material identified by Microsoft is indeed ancillary and only incidental to that functionality. The tribunal was not saying that those works were insubstantial, that's paragraph 174 of the judgment, but rather that the reason for their inclusion was in order to enable the user to run or fully to use the programs so that they may fulfill their function. And in cases at that end of the spectrum, we say the software directive exhaustion regime should apply, as the tribunal held in this case. But it's worth looking at two obvious results if Microsoft's approach is the correct one. First, it would mean that very many existing software products, including substantially all enterprise software which has a user interface, a graphical user interface, cannot be resold because non-program material is embedded within the product. And secondly, even where one could envisage a software product that consisted in principle entirely of program material with no non-program material at all, the exhaustion regime could be circumvented very easily by the developer burying some non-program material within the program. In other words, if Microsoft is correct in, I'll call it its binary approach to preliminary issue 2, it means that the exhaustion regime provided for in the software directive and considered in detail in Usoft is for all practical purposes undermined and divested of all practical scope and can easily be circumvented. And I've taken those terms, divested, undermined and circumvented, from paragraph 49 of Usoft, which formed the basis of the court's reasoning in that case, albeit on a different point, the question of whether a license should be equated to a sale. But the principle applies. Now, this doesn't mean that the non-program elements lose their copyright, no property rights been lost. It merely means that in products at the program end of our spectrum, the rights to those non-program elements are exhausted along with the exhaustion of the program elements, because the right holders had the opportunity to obtain a remuneration corresponding to the economic value of the copy of the product in question, and that's the basis of the exhaustion principle. Now, one answer Microsoft give to the problem we say results from their approach is that one doesn't have to worry about cases where there is a small, where small begins and ends, amount of non-program material, because the provisions of the enforcement directive could be taken into account. Presumably Microsoft would say the court doesn't have to grant relief, but that's not, we say, a realistic or commercially practical solution. Nobody would want to deal with products on the basis that exhaustion has not occurred. Therefore, there will be infringements if the product is resold and used. But you're told that the purchaser need not worry about that because the courts will not do anything about it.
Under the enforcement directive as applied in national law, it would be difficult to see how you could run a business upon the basis that you were infringing copyright and you were throwing yourself on the mercy of the court not to grant some form of injunction which undermined your business when it drew a fair balance between legitimate existing copyright and something else. It's an entirely different evaluative exercise as it arises at the point of relief.
Yes, we would absolutely agree with that. It's not an answer to the problem that would confront industry if Microsoft is right on this point. So could I then, with that explanation of what we say the lie of the land is, take you to the starting point, which you may say is the treaties. And I won't take you to it now, but for your reference, in paragraphs 20 to 23 of the case called Wright against BTC Core, which is in the bundle at A1, bundle 1, 13, page 220, Lord Justice Arnold provides quite a detailed list of the relevant treaties and some background. It's a convenient summary. But if I could go straight to the treaties which are in bundle A3, authorities A3, and start with Bern, which is at tab 37, page 837. I'm only going to do the treaties quite briefly, but so Bern's quite a remarkable achievement actually. The UK, all member states of the EU, and most other states in the world are parties to it. I believe there's about 182 contracting nations. And we saw from page 840 that Article 2, looked at this yesterday, makes provision for the protection of literary and artistic works. There's no specific mention of computer software, that's not surprisingly, at least when it was originally drafted in 1879. There's no specific mention of computer works. Some jurisdictions had no particular difficulty in considering computer programs to be literary works protected by copyright, and some did. But more relevantly for present purposes, exhaustion of copyright is not mentioned anywhere in Bern. It's generally accepted that so far as Bern is concerned, the application of exhaustion rules is left to regional or national legislation and case law rather than international mandate. The next treaty in order of date is TRIPS, Trade-Related Aspects of Intellectual Property Rights. That's at tab 41, page 854. Again, the UK and the EU and all its member states, as well as many other parties. In fact, it's mandatory for all members of the World Trade Organization, as I understand it, to sign up to TRIPS, and there's about 166 members as parties. Article 9 on page 858, as you might expect, refers back to Bern, which is the core starting convention, and at 2 is the familiar copyright protection shall extend to expressions and not ideas. But Article 10 introduced a requirement on parties to protect computer programs as literary works under the Bern Convention. So that's it, they are for sure a literary work, although some parties had got to that point beforehand. But again, TRIPS leaves exhaustion of rights to regional or national legislation and case law. And then the third treaty is the WIPO Copyright Treaty, which is at tab 45 of this bundle. That's page 882. And again, this was agreed in 1996. And again, the EU, the UK and the EU and all member states are parties. We looked yesterday at Article 6 on page 891. And you see footnoted in quite small print, actually, the agreed statement. It's footnotes 4 and 5. Now, just let me explain what we say this means, and I'll explain how we get there. What this means is that member states, what Article 6.1 means, is that member states must provide a distribution right in addition to other rights, but they must provide a distribution right under Article 6.1. And what the explanatory note explains is that must be a distribution right in respect of tangible copies. Then Article 6.2 says you must grant the distribution right, but you're free to determine how the exhaustion regime should apply to those tangible articles. But the important point is that Article 6.1 doesn't require as a minimum standard for a distribution right to be provided for intangible copies. So it doesn't affect or restrict the ability of contracting states to provide for a distribution right in respect of intangible works. And if a region or a state does, it doesn't provide, it doesn't specify what that exhaustion regime should be. And we can see, we can close bundle A3 now, and if I could just take you to the WIPO Guide to Interpretation, which is in bundle 4, tab 46, at page 901. And just for reference, we cover this in paragraph 16 of our skeleton. Yeah, tab 46, page 901. This is the WIPO, World Intellectual Property Organization guide to the treaties. And the relevant provisions are 6.3 and 6.4 on page 917. 8.13 on page 924. But if you look at the bottom of page 916, 6.3, and 6.3 is explaining that the right of exhaustion has been left completely to national legislation. And then at 6.4, in the middle, it starts, the minimum obligation consists in extending the right of distribution to the making available of tangible copies. So what it's making clear is it's laying down a minimum, but not dealing with intangible material. And a similar point is made in CT 813 on the bottom of page 923, but I need not take you to that now. Sorry, could we just go back to bundle A3 and have a look at Tom Cabinet, just one passage in it. I'll look at Tom Cabinet in more detail. But if you could look at bundle A3, Tom Cabinet, tab 28, page 651.
Sorry,
Tab 28,
28.
page 651. At the bottom. And this is the passage you saw yesterday at paragraph 40. The reference is made to the WCT and Article 6.1, and at the bottom of the page it says that Article 6.1 cannot cover the distribution of intangible works, such as e-books, making it clear that. And then what the court did in Tom Cabinet was to go on to say, so the EU was free to decide what it did about distribution right for intangible copies and exhaustion. So our point is that there's nothing in any of the treaties which mandates the approach suggested by Microsoft or is contrary to the approach we urge on you. And we make this point that all these treaties are applicable to all forms of copyright work, including computer programs, so that any suggestion that a right of exhaustion is not permitted in respect of intangible, non-physical works by these treaties would mean that the EU itself is in breach because of the decision of the Grand Chamber in Usoft, which provided for exhaustion of intangible copies of software. So then a short point about the interplay between the two directives. We mentioned this in paragraph 62 of our skeleton, and it's picked up by the tribunal in its judgment. But the point is that the cross-reference between the two directives, InfoSoc and Software Directive, is not symmetrical. Could we go to Authorities Bundle A1 and have a look at Article 8 of the Software Directive first? That's at tab 3, page 26. And sorry to have to go back to this, but it's important to understand the interplay between the two directives. So Article 8, this is the Software Directive provision, says the provisions of this directive should be without prejudice to any other legal provisions such as those concerning patent rights, trademarks, unfair competition, and so on. It doesn't reference the InfoSoc directive. Obviously it didn't in its original form, not in its codified form either. But rather it's directed to rights other than copyright, presumably for the obvious reason that it absolutely does affect copyright, since the whole point of the software directive is to provide for copyright protection for computer programs and the relevant exceptions and so on. By contrast, if we go back to Article 1 2A of InfoSoc, which is at tab 1, page 9 of the bundle, this does at sub 2 say that this directive shall leave intact and shall in no way affect existing community provisions relating to legal protection of computer programs. And we make the point, and the tribunal made the same point, that if Microsoft is right, it certainly does have that effect in substance, at least so far as exhaustion in relation to computer software is concerned. And of course, because the software directive is a lex specialis within the field of copyright, it's inevitable that its provisions may overlap with those of the InfoSoc directive, which also concern copyright. So the short point is that there's nothing in Article 8 of the software directive that conflicts with or precludes the tribunal's approach. So now I'm going to take you to the authorities which we say support our position. And I'll do this in generally date order so that you can see how the cases evolved. There's a fair amount of ground to cover, and you'll see some of it yesterday. So please ask me to slow down if I'm going over points you haven't seen before, or speed up if they're familiar to you. Could I begin first with BSA, Business Software Alliance in English? That's at Bundle A2. This is the case with a name that nobody can pronounce. Bundle A2, tab 18, at page 361. And this case was an important one when it came out, because there were two questions that... What happened was the user interface of a computer program was shown on TV. Broadcast on TV. Graphical user interface, or GUIs, jargon. There were two questions that were asked. We can see that there are two questions that were asked. The first question, that's at H7, for example, on page 362. The first question is, was the graphical user interface something protected by the software directive? No, that was the question. So the program itself was obviously protected, but was the graphical user interface protected as part of the software directive? That was the question. And the second question that was asked was, if that's right, does television broadcasting, whereby the public is enabled to have a sensory perception of the interface of the program or part of it, although you can't interact with it, constitute making a work available to the public within the meaning of InfoSoc? And the answer given by the court was that the graphical user interface was not a program, but the court went on to say, but by the way, it might be a work protected under the Information Society Directive. So that was an important clarification. And that's where we are with the law now. Interestingly, the court answered the second question by holding that the broadcasting of the GUI on television did not amount to a communication to the public of the GUI, contrary to Article 3.1, because it couldn't be used. And I'll come and show you the relevant passage, but can I just make two very short points, well, one very short point really. This decision predates USoft CJEU by about 19 months. The president of the chamber, Judge Baron Lennertz, was the judge rapporteur in USoft, and the Advocate General was the same in both cases. So it can't be said the Grand Chamber in USoft wasn't fully aware of BSA and its implications. And it's a small point, but it's worth noting they didn't say in USoft, by the way, if there's a graphical user interface in the software we're talking about, you better look out for InfoSoc. They didn't say that. And it can't be said they weren't fully aware of BSA. Secondly, the second point, though, is it's instructive to see why the court decided broadcasting was not a communication to the public. And we see that on page 382 of the bundle, paragraph 57. It's not sidelined, but it's the conclusion. And it essentially says that because there was no interactivity, which the court considered the essential element characterizing the interface, there was no communication to the public of the interface, notwithstanding that the public could actually see the interface on the TV. And we say that is support for our proposition that the court takes a practical approach and not a literal approach. It didn't say that because the graphical elements could be seen, they must be communicated. And it exemplifies an approach requiring one to look for the essential elements of a work, which we say is entirely consistent with our submissions. The next case in date order then is USoft, and of course that's at tab 20, page 427. Of course, USoft's relevant to both PI2 and PI1, but for the moment, if I may, I'm just going to focus on the PI2 issue and deal with splitting later when I deal with splitting as a concept. But in very simple terms, if one looks at paragraph 22, we'll have to look at this in a bit more detail when we come to look at splitting. Paragraph 21, I'm sorry. So paragraph 21 explains that we're dealing with client-server software. So there are two rights that are being granted here. One is a right to install and store and run a copy of the Oracle database server on the server. And the other right is we call the user right, which is the access right that users of workstations can have to that software. That's relevant to PI1, of course. But there are two distinct rights being granted there. One is a user right, and the other one is the right to install the database software on the server. And the way client-server software works, particularly with Oracle database, the server runs the database, and workstations can access and send queries, they're called, to the database and get information back, or send information to the database and get it stored on the database and do other things with the database. But the database is the thing, the server software is the thing that's running the database.
So it's a matter of terminology. The user right doesn't include the download. It's what happens after the download and installation.
Yes, so in this case, yes, you can install and run the software on the server, and then if you want to access the server, we can see that
Yes, I see.
at 22.
Yes.
If you then want, you can run that there, but if you want workstations to access the server, you need to buy batches of access rights in 25, in batches of 25, so 25, 50 or whatever.
And that's relevant to what you said at scope of 69 onwards.
Yes, well, yes, exactly that.
But
That-
anyway,
I'll
yes,
come
yes,
to
I
that,
see.
but
Right.
that's just, I'm covering that fact
Yeah, no, I understand.
now. Yes, but that's the technology behind this.
Just, Mr. Higgs, just on, you're describing two rights. The word user right in 21
Yes,
refers to both the right to store on the server and the right to use a certain number of access.
yes.
The word right isn't used twice in different senses in that paragraph.
No, you're right. Sorry. The user right includes two rights: a right to install and run, and then a right for users to access that software. But that's really relevant to PI
No, sure.
too. But yes. So, para 26. And I know this is a familiar ground to you probably, but in paragraph 26, the point was that if you didn't have the software and you purchased it from Usoft, you could go directly to Oracle's website after acquiring the license and download it. And now we've referenced several paragraphs in our skeleton, and I won't take you to them all, but if I could pick it up at paragraph 44. And what the court says here is that the downloading of a copy of a computer program and the conclusion of a user license for that copy form an indivisible whole. Downloading would be pointless if the copy can't be used by its possessor, and those two operations must therefore be examined as a whole for the purposes of their legal classification. And then reference is made to Club Hotel Loutraki. And I'll take you to that next. But we say that logic extends to the user license in this case relating to program and non-program elements. You've got to look at the transaction as a whole for the purposes of its legal classification. And where you have two directives that might apply, we say that Club Loutraki shows that you apply one but not both. You can apply one but not both in appropriate cases. And the point is made is that if that's not done, a purchaser won't be able to enjoy the ownership right in the copy. And then at 45, the court explains the justification for the exhaustion principle, which is the right at the end, the customer, in return for payment of a fee, the copyright holder is enabled to obtain a remuneration corresponding to the economic value of the copy of the work of which it's the proprietor. So that's the justification has the right holder, by selling the software, been able to obtain a remuneration, in principle corresponding to the economic value. Then at paragraph 47, the court dealt with the problem of, well, does it make a difference if Oracle supplied the software on a CD or a DVD? And the court concluded no, at 47, it makes no difference. Again, looking at the thing from a practical matter and a commercial matter, from a commercial point of view. And then the next point the court had to deal with was that article, which it deals with at paragraph 47, 48, the court says, well, we say that the conclusion of the contract counts as the first sale of a copy of a programme. But then the next point the court had to deal with at paragraph 49 is that Article 4.2 of the Software Directive says exhaustion occurs when there's a first sale of a copy of the programme. You can see that from the concluding words of 48. And the point the court is making is, if first sale is not given a broad interpretation encompassing all forms of product marketing characterised by the grant of a right to use a computer programme for an unlimited period in return for payment of a fee, the justification for exhaustion, then right at the end, last 3 lines, the effectiveness of that provision would be undermined, since suppliers would merely have to call the contract rather than a sale in order to circumvent the rule of exhaustion and divest of all scope. So that plays back into our point that the similar point applies here. If all you needed to do to escape use soft, even in a case which was purely program material, was to put some non-program material in it, you would be very easily able to circumvent and divest of all scope, and so on. The next point that the court dealt with, which is relevant for PI2, is that Oracle's argument was that making a copy of the software available on its website was an act of making it available to the public within the meaning of Article 3.1 of the Information Society, which was a right that can't be exhausted. And that argument was rejected in paragraphs 50 to 52. And what is said is that it is essentially, in cases of this kind, the sale or permanent divestment of the copy has got to be treated as a distribution to the public, i.e. falling under the distribution right, which can be exhausted, rather than falling under the communication to the public right, which can't be exhausted. So that's how the court deals with the difficulty that you might say, but I made it available to the public from my website, so I'm communicating it to the public, and that right can't be exhausted. What the court says, no, you look at what the transaction is. In reality, it's a distribution, and therefore the distribution right, rather than the communication to the public right of Article 3 of the InfoSoc Directive is distribution right of the software directive is the applicable right. So again, we say it's very consistent with the approach we adopt. Essentially what the court said in 52 is that a transfer of ownership changes an act of communication within the meaning of Article 3 into an act of distribution. And then from paragraph 53 onwards, the court had to consider whether the exhaustion regime provided, if you look at the bottom of page 461 and top of page 462, the court then had to consider whether the exhaustion regime provided for in Article 4.2 of the Software Directive only applied to tangible copies, such as DVDs or CDs, and was not applicable to intangible copies of computer programs. And after some analysis on page 462, the court concluded this argument was wrong, and I can pick the judgment up at paragraph 62 on page 463. They are dealing with the Commission's argument that, well, intangible copies may be akin to services, but they then remind again oneself of what the principle of exhaustion is. It's in order to avoid partitioning of exhaustion, to limit restrictions on the distribution, to what's necessary to safeguard the specific subject matter. So they do refer back to the old intra-EU, intra-community, interstate trade provisions. What's the specific subject matter? And then they apply that to the exhaustion principle in 63, which is your rights exhausted, again, because the right holders, this is 63 in the middle, the first sale already enabled the right holder to obtain an appropriate remuneration. Such a restriction on resale would go beyond what's necessary to safeguard the specific subject matter. So that's how we get to the software directive covering both tangible and intangible distribution. Then at 64, there was another issue raised, which essentially is this: did it make a difference that the new purchaser, the new acquirer, when they wanted the software, which they'd purchased via Usoft from the original acquirer, what they got was effectively an updated and corrected version of the software, rather than the version of the software that was first sold to the original acquirer. And the court at 67 and 68 said, no, it's still exhausted. So you can see at the end of 67, the functionalities corrected, altered, or added form an integral part of the copy original downloaded and could be used by the acquirer of the copy for an unlimited period. So again, they're looking at the thing as a whole. You bought the uncorrected version. You had a maintenance agreement which allowed you to get updated and corrected versions. You could sell that updated and corrected version. So again, we say that's the court looking at this thing in an overall commercial sense, always with an eye to what the rationale behind the exhaustion regime is.
Which was adequate remuneration. So if you purchased a maintenance contract at the outset, you assumed that it was applied to the product over time, and therefore you got your remuneration when it was resold.
Yes. Now, then the conclusion on this point is at 72, and yet again, and it talks about even where the, perhaps let's have a look at 672 is the summary of all those points put together. And again, the court just underlines the core principle behind exhaustion. There's So there we are. It's a broad exhaustion. The new acquirer can download the updated corrected version. It doesn't matter whether Oracle sold the software originally on a CD or DVD or an intangible form. It doesn't matter if you call it a license or a sale. You've got to look at the transaction as a whole. Now, there's one further point which is of relevance to this case. It may come in under PI1, but I might as well deal with it now. What is the position of the original acquirer of the software? What must it do? And essentially we say what the court is concerned with is to ensure that this exhaustion regime doesn't allow the number of copies in use to increase. Number of copies in use. So at paragraph 70, they make the point, and this is picked up by the tribunal in paragraph in paragraph 101 of the tribunal's judgment, that the original acquirer must not then use the copy of the software sold. Obviously not. If you sell a piece of software, you mustn't continue to run it and use it. And the same point is made at paragraph 78. So the exhaustion occurs at the time of sale. You can then resell according to USoft. But if you do, you as the vendor must not continue to use the copy you sold. So,
can I just ask how that would work if you originally acquire a user right covering 1,000 users, and then you sell off that 1,000 in tranches of 250? Can you, as the original acquirer, continue to use the number you haven't sold off? When do you have to relinquish your total rights? Is it a rolling reduction? Because there's that word "at the time," but it's
yes.
I mean, it seemed to be the assumption is you sell it all off at once, and if so, you must relinquish at the time.
Well, what we say, I'll perhaps come to that when I deal with it, but what we say is that exhaustion arises on a copy by copy basis. For each copy you acquire, you can sell that copy, and then you must stop using that particular copy. In the case of server software, though, you've got these two licenses, if you like. You've got the one license to install software on the server and run it, and then another ability for users to access that server. What you can't do, and I'll come to this in more detail when I come to PI1, is to say, well, look, I've got a 10 user license for that server. I can run the server and I've got a 10 user license. What I think I'll do is I'll sell off the right to the server. So now the new purchaser's got the server software, and I'll just keep 5 user rights, and the new purchaser can get 5 user rights, because in that case you've got 2 copies of the server software. That's what we say is the prohibition against splitting. It's not just splitting, it's you're duplicating the server license. But as I say, I'll come to that in more detail when I look at USoft, when I look at PI2. The next decision, we go back in time a bit to Club Hotel Loutraki, which is at A2, Authorities 2, tab 17, page 316. And I'll try to summarise it rather than spend a long time reading it. The case involved, now, by the way, the tribunal referred to this case in its judgment at paragraphs 157 and 171 and relied on it, and we cover it in paragraph 56 of our skeleton. But in a nutshell, the case involved privatisation of a state-owned business. There was a contract proposed whereby 49% of the shares in the casino business were to be sold to a single purpose company. But the contract proposed also included agreements whereby the company would take over management of the casino and refurbish the develop buildings. And the problem was that the share sale part of the agreement was not covered by EU rules on public contracts. But there was a question as to whether the services part of the agreement was covered by the EU procurement rules. And the relevant part of the judgment and the passages referred to by the court in USOF is, so I've lost my page, page
48.
yeah,
356.
356, I think it is. 356.
The main object.
The main object point, yes. 356, sorry, yeah. Paragraph 48, yeah, the main object point. You have to look at what the main object or predominant feature of the contract is. And we say that feeds directly into our spectrum. What is the main object or predominant feature of the complex matter? Is it really art, literature, that sort of thing? Or is it really a programme? So
This was the paragraph cited in Tom Callan's.
cited in USOF, 48 and
USOF,
49
USOF.
were cited in USOF at 44, yeah.
Yes, of course, thank you.
Next then, Nintendo, which is at A221. We discussed Nintendo in paragraphs 40 to 42 of our skeleton, and it's mentioned in several places in the judgment of the tribunal. Now, this is the case which seems to have introduced the term complex matter, but to summarise, this was not a copyright infringement case. Nintendo's claim was for under Article 6 of the Information Society Directive to oppose a special right, to oppose the use, as a special right, to oppose the use of devices used to circumvent technological measures intended to prevent copyright infringement. So if you put a technical measure in which prevents copyright infringement, there's a separate right to oppose the use of those circumvention devices. It's not a copyright, but it's an additional right. But that's part of copyright. Now, the claims could only be advanced under that provision if the games were works protected under the InfoSoc directive, as there are no exactly equivalent rights for computer programs. Could you first go to page 16, para 16, on page 473. At the bottom, just so that one understands what the reference was. The court referring said that the protection of video games cannot be reduced to that provided for computer programs. Indeed, although they take their functionality from a computer program, they begin and progress following a narrated predetermined route by the authors of those games in a way to make up a group of images and sounds appear together with some conceptual autonomy. And then the court queries whether these fall within the scope of the Information Directive provision. So that's in a sense a finding of fact. We say a finding of fact that the games in issue at the Information Society Directive end of the spectrum, which we propose. If you could then go to para 21, which you of course looked at yesterday, and this passage sidelined between 21 and 23 is important and relied on in support of our case. So 21 is simply setting out basic principles, info pack. 22, they talk about as regards the parts of a work, should be borne in mind there's nothing in InfoSoc that those parts are to be treated any differently from the work as a whole. In other words, you must look at everything as a whole. It follows they're protected by copyright, since as such they share the originality of the whole. So this is the whole work approach to the Nintendo issue. And then at 23, perhaps you could just remind yourself of that. I think you looked at it yesterday. So we draw 3 points from this. The first is that the Court of Justice did not approach this issue on the basis that the video game was an agglomeration of discrete works, each subject to one or other of the directives. The decision was that the entire work was subject to the Information Society Directive, despite being complex matter. Secondly, it reasoned that specific parts of the game could, if taken in isolation, be subject to the InfoSoc Directive, but it didn't resolve it on that basis. It resolved it on the overall basis that Article 6 applied to the video game as a whole, not just to the works or bits of it in isolation. So again, we say that supports our case, that where an issue such as an exhaustion is concerned and relates to a work as a whole, it must be resolved by categorising the work under one or other directive. Now, put against us is the opinion of Advocate General Sharpston, which you can see at page 488 of the bundle. And if I could just pick it up at AG 31 at the top of the page, just to understand how her opinion is put together. So at AG 31, there's a finding of fact that the games are not computer programs, but complex multimedia works falling within the scope of the Information Society Directive. That's the finding of fact. At
Can we
30,
take it that the finding of fact was, in a sense, principal object or what predominantly?
yes,
So it's a complex product, but primarily it's non-software related copyright.
yes, yes. And then, because at 32, Poland suggested the findings might be queried, but at 33, the Advocate General says, it seems to me this court has no reason and no competence to reassess the facts found by the referring court. So that's the starting point for her analysis. And then at 34 and 35, the Advocate General reaches the conclusion that the InfoSoc regime applies to these particular measures. And the passage particularly relied on by Microsoft is right at the bottom of page 488, which is essentially where you've got the two directives. Essentially, you can pick the stronger. Now, we say, we make 4 points in relation to this opinion. First, the approach of the Advocate General is not the same approach as adopted by the court in its judgment. It looked at it as a whole. Secondly, the Advocate General was not considering exhaustion of copyright. She wasn't considering copyright directly, nor exhaustion. She was considering protection given to rights holders in respect of technical protection measures, TPMs in the jargon, and her conclusion was rightly that that protection shouldn't be undermined by the presence of some program material falling within the scope of the software directive. However, the exhaustion regime gives rise to different considerations. and in particular the consideration of whether the rights holder has had the opportunity to receive remuneration corresponding to the economic value of the work. Just different consideration. Exhaustion protects consumers and public against the use of intellectual property rights beyond their specific subject matter, whereas the TPM has got a different objective. And so following the logic of the Advocate General, we say that the presence of some non-programme material in the case of the programme end of our end of the spectrum, such as Office and Windows, that presence should not be allowed to trump the exhaustion regime of the software directive. The greater protection for consumers and the public, namely exhaustion, should be the determining factor in cases at the programme end of the spectrum. Whereas, of course, if one's considering Article 6 and technical protection measures, different provisions and different considerations apply.
So it does depend on who's going to get the greater protection, whether it's the licensee or the licensor.
Yes, exactly.
Is she referring here to the licensee or the licensor protection?
She's referring to neither. She's simply saying, well, the licensor. Yes, she's saying that yes, the licensor gets a greater protection. Yes, the right holder should have the greater protection in the case of
the right holders. Yes.
Yes. Yeah.
But your point is, the point she's talking about is TPMs, technology protection, which is designed to protect licensors, and so the greater protection for the thing it's designed to protect should be given. The point you make, rightly or wrongly, is you say exhaustion is there to protect the consumer, and that's the argument.
That's the argument we're putting forward. Yes, and our third point is that the conclusion reached is readily understandable in a finding of when the reference is a finding of fact that it's a complex multimedia work. And the Advocate General wasn't considering cases at our end of the spectrum or exhaustion cases. And I mean, fourthly and bluntly, if it was intended to be a general statement of the law for all purposes, including exhaustion of copyright, and for all cases of complex works, it's wrong. But there's no reason to suppose that the Advocate General intended
So it's understandable in the context in which it was being described.
Yes, yes. Perhaps if I could just show you one passage from USOF 3 before the short adjournment. It's bundle A4, tab 49, page 998. I'm just dealing with these in date order. This is the BGH decision in USOF 3. And again, it follows in date order. Tab 49. And all I wanted to show you is at page 1001, one can see that the software in question was Adobe software, consumer Adobe software, and it would clearly incorporate non-program works. So maybe said the point wasn't argued, but the point was the BGH had no difficulty in applying the USOFT regime, exhaustion regime, in the case of USOFT 3 to Adobe products, which most clearly had a GUI protected under BSA, under the software directive. So I'm now going to move on to ranks. I don't know whether that'd be a convenient moment to stop, or would you like me to?
Yes, I think so. Nearest makes a difference. 5 o'clock. We'll see you at 2 o'clock, Ms.
All advised in favour?